It looked routine, stamped with the Willow Ridge Estates HOA logo, printed in bold black ink that always felt more like a warning than a greeting. At first, I assumed it was another generic reminder about lawn edging or trash bin placement. Willow Ridge was a kind of neighborhood where grass height was practically a competitive sport. But when I unfolded the letter, the reason for the violation made me blink. Unauthorized tree. Not overgrown. Not diseased. Unauthorized. The oak tree in question had been standing in my front yard longer than I had lived in the house. According to county records, it had been planted nearly 15 years earlier by the original developer as part of the community landscaping plan. It wasn't new. It wasn't obstructive. It wasn't dead. It was simply there. The notice stated that the tree violated updated landscape symmetry standards adopted during a recent board session. It claimed the tree disrupted the uniform visual flow of the street and demanded removal within 30 days. Failure to comply would result in a $200 weekly fine. $200 a week. For a tree. I walked outside and stared at it. Its branches stretched wide, leaves thick and green, providing shade over the driveway and part of the sidewalk. In summer, neighbors walking dogs paused beneath it. Kids rode bikes through the shadow it cast on the pavement. There was nothing offensive about it. That night, I pulled out my closing documents. The original landscaping map clearly showed the oak marked as a permanent developer installation. I logged into the HOA portal to check for updates to the bylaws. There were none. No mention of landscape symmetry standards. No posted amendments. No meeting minutes announcing such changes. The next morning, the first fine felt personal. The second felt strategic. By the third week of $200 penalties stacking against my name, it became clear this wasn't about landscaping. It was about pressure. The board wasn't trying to fix a violation. They were trying to force compliance through financial exhaustion. Instead of paying, I started documenting. I requested a full financial statement from the HOA for the past 2 years. Under state law, homeowners had the right to inspect association records. The management company responded with delays, citing processing time and archival retrieval. That phrase alone raised alarms. Willow Ridge was barely a decade old. There shouldn't have been any dusty archives to retrieve. While waiting, I started talking to neighbors more intentionally. Patterns began to emerge. Mrs. Dalton at the corner had been fined $1,100 over non-conforming flower beds. She had replaced them exactly as instructed, yet the fines hadn't been removed. A young couple on Maple Court had received repeated notices about a driveway crack that city code inspectors had already deemed cosmetic. Selective enforcement. Escalation without resolution. But what stood out most was timing. Nearly everyone who had questioned the recent HOA dues increase had suddenly found themselves under scrutiny. It wasn't random. It was targeted. 3 weeks later, I finally received partial financial documents. They weren't complete, but they were enough to raise eyebrows. A new expense category had appeared in the ledger 6 months earlier, Consulting and Landscape Compliance Review. The amount? $48,000. That number felt wildly disproportionate for a neighborhood our size. The payments were routed through an LLC named Greenway Community Advisors. The registered agent for that LLC? Harold Mercer's home address. The same Harold Mercer who insisted the tree violated landscape symmetry standards. I pulled public records to confirm. The LLC had been formed 2 months before the dues increase vote. It listed Mercer as managing member. There was no disclosure in any HOA meeting minutes about hiring an external consultant, let alone one owned by the board president. That's when the situation shifted from questionable to potentially illegal. If HOA funds were being funneled into a company owned by its own president, homeowners had a right to know. If fines were being aggressively issued to inflate revenue that ultimately funded that company, the implications were even worse. I cross-referenced the dates. The spike in fines across the neighborhood aligned almost perfectly with the first large payment to Greenway Community Advisors. More violations meant more collected fees. More collected fees meant more money flowing through the association's accounts. And from there, into Mercer's LLC. It wasn't just mismanagement. It looked like a revenue engine. The tree fine suddenly made sense. It wasn't about aesthetics. It was about setting an example. If they could force me to remove a developer-planted oak and pay thousands in penalties, everyone else would fall in line without question. Fear is contagious in neighborhoods governed by liens. But information can be contagious too. I compiled everything into a clean, organized report. Public filings, financial summaries, timeline correlations, and screenshots from the HOA portal showing the absence of any posted amendment regarding tree symmetry standards. Then I quietly shared it with 5 trusted neighbors. The reaction was immediate: shock, anger, disbelief, and then something more powerful: momentum. Within days, that report had circulated through private neighborhood groups and email chains. Residents who had felt isolated in their individual disputes began realizing they were part of a larger pattern. The board responded predictably. Another letter arrived at my door. This one accused me of disseminating misleading financial interpretations and warned of possible defamation claims if I continued to damage the reputation of the association. The fines for the tree were now at $1,200. The tone of the letter suggested escalation, but something had changed. For the first time, the board wasn't speaking to a single homeowner. They were reacting to a growing audience. The next HOA meeting was scheduled for the following Thursday. Rumors spread that attendance would be higher than usual. What the board didn't realize was that this meeting wouldn't be about landscaping. It would be about accountability. And once the right questions were asked publicly, there would be no stuffing the answers back into sealed envelopes. By the time Thursday evening arrived, the energy in Willow Ridge Estates felt different. Cars lined both sides of the street, leading to the clubhouse. Porch lights flickered on earlier than usual, and small groups of neighbors stood in driveways whispering, clutching folders and printed emails. The orange violation tag on my oak tree had become more than a notice. It had become a symbol. Inside the clubhouse, folding chairs filled quickly. Normally, HOA meetings attracted a predictable crowd of fewer than 20 residents. This time, nearly the entire neighborhood showed up. Some came out of curiosity. Others came with quiet frustration that had been building for months. At the front of the room sat the board, Harold Mercer in the center, posture rigid, expression controlled. On either side, the vice president and treasurer shuffled papers in neat stacks. Their calm appearance clashed with the restless tension in the room. The meeting began with routine formalities: budget summaries, landscaping updates, maintenance scheduling. The board moved quickly, as if hoping to glide past a real issue before it surfaced. But it surfaced anyway. Hands began to rise. Questions about recent fines. Questions about the new landscape symmetry standards. Questions about the sudden spike in consulting expenses. Mercer attempted to maintain authority, referencing internal reviews and strategic initiatives. The tone remained polished, but the details were thin. Then the financial documents were mentioned. Several homeowners now had copies of the report I had compiled. Pages showing the formation of Greenway Community Advisors. Public filings linking the LLC to Mercer's home address. The $48,000 in consulting payments that coincided almost perfectly with a wave of new violations. The room shifted from uneasy to electric. For the first time, the board was not controlling the narrative. Mercer insisted that hiring outside consulting was within his authority as president. He framed it as proactive governance, necessary for long-term property value protection. He emphasized that all actions were taken in the best interest of the community. But there was one problem. No formal vote authorizing the contract appeared in any meeting minutes. No disclosure had been provided to homeowners. And state HOA regulations required transparency in contracts involving board members. The absence of documentation spoke louder than any defense. The treasurer attempted to redirect attention, suggesting that the payments were standard operational expenses. Yet, when pressed about why the LLC had been formed just months before enforcement intensified, the explanation became less steady. The crowd grew louder, not chaotic, but unified. For years, neighbors had handled their frustrations privately. Small fines, small annoyances, quiet compliance. Now those individual grievances had merged into something larger. A pattern. Someone presented copies of the subdivision's original environmental filing with the city, documents confirming that the oak trees were developer-installed and potentially protected. The implication was clear. Demanding removal might not only be overreach, but a violation of municipal guidelines. Mercer's composure began to crack. The threat of defamation letters, once intimidating, now looked defensive. Attempts to silence discussion only amplified suspicion. The vice president quietly reviewed documents passed forward by homeowners. The treasurer stopped making eye contact. The two quieter board members exchanged tense glances. Then came the question that changed everything. If the consulting contract was legitimate, where was the written conflict of interest disclosure? Silence lingered longer than comfortable, because there wasn't one. Under state nonprofit governance rules, board members were required to disclose financial interests in contracts involving association funds. The absence of disclosure wasn't just poor communication. It could invalidate the agreement entirely. The room no longer felt divided between board and residents. It felt like accountability had finally arrived. A motion was proposed from the floor to conduct an independent audit of the HOA's finances and suspend enforcement of all recent landscape symmetry violations pending review. For the first time, the board looked unsure. They had expected scattered complaints. They had not expected documentation. They had not expected organization. And they had not expected unity. The vote to demand an audit passed overwhelmingly among homeowners present, while the board technically retained authority. Ignoring such a unified demand would only deepen scrutiny. The meeting adjourned without resolution. But something irreversible had happened. Power had shifted. The oak tree still stood in my yard, orange tag fluttering slightly in the night breeze. Yet it no longer felt like a target. It felt like a catalyst. Within 48 hours, news of the confrontation began spreading beyond the neighborhood. A local community forum picked up the story. Screenshots of financial filings circulated online. Questions about HOA governance reached people who had never heard of Willow Ridge Estates. The board had attempted to enforce silence through fines. Instead, they had created exposure. And exposure has a way of multiplying. By the time the weekend arrived, one board member quietly stepped down, citing personal reasons. It was the first crack in the structure, but it wouldn't be the last. The audit request was supposed to intimidate them. Instead, it exposed them. Within a week of the explosive HOA meeting, pressure mounted from every direction. Homeowners formally submitted a petition demanding an independent financial review under state association transparency laws. The petition carried more than 2/3 of the neighborhood signatures, far more than required to trigger mandatory inspection. The board delayed at first. They cited scheduling conflicts. They referenced internal accounting reviews already underway. They suggested that an external audit would be unnecessarily expensive and disruptive. But this time, no one accepted vague reassurances. Too many documents were already circulating. Too many patterns had been identified. And too many homeowners were watching closely. Eventually, the board conceded. An independent accounting firm from outside the county was retained, one with no prior connection to Willow Ridge Estates. The selection alone signaled something significant. For the first time in months, the board was not choosing its own oversight. The audit began quietly. Bank statements, vendor contracts, fine collections, payment authorizations, meeting minutes, email correspondence. Everything was requested, and everything had to be turned over. Within days, tension in the neighborhood intensified. Board members who once walked confidently down sidewalks now avoided eye contact. The clubhouse remained dark most evenings. Routine violation letters suddenly slowed to a trickle. It was as if enforcement had paused the moment scrutiny began. 2 weeks into the audit, the first preliminary findings were shared with the homeowners petition committee. They were worse than anyone anticipated. The consulting contract between the HOA and Greenway Community Advisors had never been formally approved by a majority vote of the board. There was no documented conflict of interest disclosure filed by Harold Mercer. Payments totaling nearly $52,000 had been made over 6 months. Even more troubling, the consulting services lacked detailed invoices. Descriptions were vague: compliance assessment, landscape review strategy, enforcement planning. There was no measurable deliverable attached to most payments. The revenue fueling those payments? Fines. Fine revenue had tripled compared to the previous year. The majority of the increase began the same month Mercer's LLC received its first transfer. The pattern was no longer speculation. It was documented. But that wasn't the only discovery. The audit also uncovered that several fines, including mine, had been issued under a rule amendment that was never properly ratified. State law required homeowner notification and an opportunity for comment before such amendments could take effect. No evidence of notification existed, which meant the landscape symmetry standards were never legally enforceable. Every fine issued under that rule was potentially invalid. The orange tag on my oak tree had never been backed by legitimate authority. The implications were enormous. Refunding the improperly collected fines would drain a significant portion of the HOA's reserve fund. Legal exposure for breach of fiduciary duty loomed over the board members involved. As the findings circulated among homeowners, something else happened. Another board member resigned. This time, there was no polite explanation about personal reasons. The resignation email cited unforeseen governance complications. That phrase spread quickly. Governance complications. It was the closest anyone on the board had come to admitting fault. Meanwhile, Mercer remained silent. He did not respond to informal inquiries. He did not address the growing demand for reimbursement. He did not publicly defend the consulting contract. Silence in this context spoke loudly. The audit firm scheduled a formal presentation of its findings at a special meeting open to all homeowners. The date was set. The room would be full again. But this time, the conversation would not rely on suspicion or circumstantial evidence. It would rely on professional analysis and documented financial trails. As the meeting approached, tension thickened. Homeowners prepared motions to remove board members under recall provisions outlined in the bylaws. Legal counsel began reviewing options for recovering funds. Discussions about restructuring leadership gained momentum. The oak tree still stood untouched in my yard, its leaves moving gently in the late afternoon wind. What had started as a $200 weekly fine had triggered a chain reaction. The board had assumed compliance would be easier than confrontation. They had underestimated the power of documentation, and they had underestimated how quickly authority collapses when trust disappears. The upcoming meeting would determine everything, not just whether fines would be refunded, but whether the people who had enforced them would remain in power. The night of the special HOA meeting, the clubhouse was packed beyond capacity. Folding chairs lined every wall, and homeowners stood in the back, clutching folders, printed emails, and copies of the audit report. The fluorescent lights buzzed overhead, creating a harsh contrast of the tension in the room. For months, Willow Ridge Estates had operated under a facade of order and civility. But tonight, that illusion was about to shatter. At the front table, Harold Mercer and the remaining board members sat rigidly, shuffling papers in a futile attempt to appear in control. They had prepared statements, rehearsed excuses, and polite reminders of community unity, but the atmosphere made it clear they were no longer the authority. The room belonged to the homeowners now. The auditor, a professional with no prior ties to the community, began presenting findings. The projector illuminated detailed slides. Financial transactions showing $52,000 in consulting payments to Mercer's LLC, the timeline linking fine increases of payouts, and the glaring absence of documented approvals or conflict of interest disclosures. Each slide elicited murmurs from the crowd, some disbelief, some anger, and some a growing sense of vindication. When the report reached the improperly issued landscape symmetry fines, including the $200 weekly penalty for my oak tree, gasps filled the room. The auditors explained that state law required homeowner notification and proper ratification for amendments to take effect. There was no evidence that such processes had been followed. Every fine issued under that rule was potentially invalid, and the funds collected might need to be reimbursed. The homeowners' reaction shifted from shock to coordinated determination. Questions flowed freely now, no longer polite inquiries, but pointed demands for accountability. Board members tried to interrupt, but the volume and unity of the crowd drowned out their attempts. The balance of power had shifted irreversibly. Mercer's composure began to crack. He attempted to argue the legitimacy of the consulting payments, framing them as proactive measures to protect property values. But the auditor's presentation left no room for interpretation. There was no contract approval, no oversight, and no measurable deliverables. The evidence was indisputable. A motion was raised by homeowners to remove the entire board immediately under recall provisions outlined in the bylaws. Discussion followed, and nearly every hand in the room went up to support it. The vote was overwhelming. It was the first time in the neighborhood's history that such a decisive action had been taken. Resignations followed quickly. One board member left quietly, citing personal reasons. Another, perhaps realizing the legal exposure and reputational damage, formally submitted a written resignation on the spot. Mercer remained seated longer than the others, but the pressure was undeniable. He knew that continued resistance would only worsen the fallout. Within an hour, he too submitted his resignation, ending his tenure as HOA president abruptly. The room erupted. Homeowners embraced, exchange relieved smiles, and shared quiet laughter tinged with disbelief. The audit report had not just proven financial mismanagement, it had forced the corrupt board to step down. For the first time, the neighborhood felt a genuine sense of justice. Outside, the oak tree still stood in my yard, leaves rustling in the night breeze, untouched by fines or threat. What had begun as a single $200 weekly penalty had sparked a movement that dismantled the entire board. It was a symbol of resilience, persistence, and the power of collective action. The aftermath was immediate. Discussions of restructuring HOA leadership, implementing transparent financial policies, and ensuring homeowner involvement began the very next day. The former board members, once untouchable, were now accountable, their influence diminished. And while some details of restitution, reimbursement of fines, and legal proceedings would take months to resolve, one truth was undeniable. The homeowners had reclaimed control. The balance of power, long tilted in favor of a small, secretive board, had shifted back to the people who had built the community. The sun rose over Willow Ridge Estates with a sense of quiet renewal. The neighborhood that had felt tense, fearful, and divided for months now breathed a collective sigh of relief. The corrupt HOA board was gone. Their abrupt resignations marked the end of an era defined by selective enforcement, unexplained fines, and private profiteering. In their place, homeowners began taking steps to ensure accountability and transparency would never again be compromised. The first order of business was restructuring the HOA leadership. Temporary committees formed almost immediately, composed entirely of volunteers from different blocks, ages, and backgrounds. Each committee focused on a critical aspect: finance, landscaping, compliance, and communications. Meetings were now open to every resident, with minutes recorded, posted publicly, and discussed online. The new structure emphasized checks and balances, ensuring that no single individual could wield unchecked power again. Meanwhile, the audit's recommendations guided immediate action. Improperly collected fines, including the $200 weekly penalty for my oak tree, were refunded or credited to homeowners. The total sum, though substantial, was manageable thanks to careful fiscal planning by the temporary committees. Transparency became the new standard. All payments were posted, every contract scrutinized, and any potential conflict of interest had to be publicly disclosed before approval. The oak tree itself became a neighborhood symbol. Children played in its shade once more. Neighbors stopped to admire its broad branches. What had once been the target of punitive letters and escalating fines now represented resilience, unity, and the power of informed action. Its orange violation tag remained taped to the trunk for a time, not as a warning, but as a reminder of the change one determined homeowner had helped ignite. With the corrupt board gone, the community turned to long-neglected infrastructure projects. Landscaping improvements were proposed and implemented with input from homeowners. Playground repairs, street maintenance, and common area upgrades moved forward efficiently because every dollar spent was accounted for, approved, and transparent. The neighborhood felt alive again, no longer paralyzed by fear of arbitrary fines or intimidation. The story of the audit, the fines, and the eventual board resignation spread quickly beyond Willow Ridge Estates. Local news outlets picked up the saga, framing it as a case study in the dangers of unchecked HOA power. Residents were interviewed, documents were analyzed publicly, and legal experts praised the collective action that had overturned decades of mismanagement. Some neighbors had never been involved in local politics before, but now they had become advocates for transparency, not just in Willow Ridge, but in other nearby communities. As weeks turned into months, the neighborhood culture began to shift. Annual HOA meetings were no longer perfunctory events dominated by a few voices. Instead, they became opportunities for open discussion, collective decision-making, and accountability. Volunteers rotated responsibilities, and mentorship ensured that newcomers understood their rights and responsibilities. Fear had been replaced with empowerment. On my own property, the oak tree remained a central fixture. Its leaves rustled gently in the wind as neighbors passed by, waving and exchanging smiles. What started as a single $200 weekly fine became a catalyst for change far beyond one homeowner's yard. It proved that even in tightly controlled systems, careful documentation, persistence, and unity could overcome entrenched corruption. By the end of the year, Willow Ridge Estates had transformed. It was no longer a neighborhood governed by fear and arbitrary fines, but a community strengthened by trust, transparency, and accountability. The story of the tree, the audit, and the resignations became part of local legend, a cautionary tale for HOA boards and an inspirational example for homeowners. The oak tree still stood tall, its shadow stretching across the yard in the late afternoon sun. It had survived the threat of removal, fines, and intimidation. It now symbolized not just resilience, but the collective power of a community that refused to be silenced. And while new challenges would inevitably arise, the people of Willow Ridge Estates knew one truth. Together, they could hold anyone accountable. The chapter and the saga closed not with a sense of finality, but with hope, vigilance, and the restored promise of fairness.